This is a good question about mediation, the benefits, the drawbacks, and let me go ahead also clarify that during the eligibility process for 504 or IDEA, especially under IDEA, if the child has behaviors, all right, and let's say that there's a cycle or a component of discipline in there during the eligibility process, your child has rights in the interim that the school needs to chill out during that time frame, and that's specified in there. So your child during that eligibility process is protected under the same rights. In fact, it's sort of presumed eligible until the data comes back to say that the child is not eligible. And I think that the thought process behind that is so that during the eligibility process, which could take 60 days, and it could take up to 90 days until you get an IEP in place, I think the intent there is so that the situation doesn't continue to spiral out of control. So those rights are there. And the other thing is that a parent has rights along with the child during the process because of something called child find. So under the child find provisions, which is that basically states that the district has the responsibility to identify children within their boundaries that may have a qualifying disability and be in need of specialized instruction. All right. And that's any child within their geographic boundaries. That's homeless, migrant, homeschool. It doesn't matter. So if they have a child find mandate and they suspected or should have known, and that's another aspect, if the district suspected or should have known that your child had a qualifying disability and was in need of specialized instruction, then at that point, they're on the hook. They're in trouble. And so you still have rights even before eligibility to protect your child, but then also would put you in a position to demand compensatory or remedial services if your child does qualify. Now, that would track back, once again, depending on the state you're in. Some states have a 1-year statute. Most states have a 2-year statute to where at the point of eligibility, you can track back 2 years. And during that analysis of tracking back 2 years, the analysis would be when the district suspected or should have known that your child was one who required an IEP. And then, if it was 6 months prior or a year prior, then that time period, they would need to sit there and negotiate some compensatory or remedial services to try to make up for what they failed to do in their child find responsibilities. It is not your responsibility. So now that you're over that, I'm glad. See, this is how you sort of know, is that during the process, they sort of promised to stop doing what they were doing. So they did know that much. Now, what are the benefits or drawbacks to mediation? There isn't any. The states will provide mediators, trained mediators. Most of the mediations they can occur in a conference room type setting, but most of them occur in what we call caucus, to where the school people are in one room, you're in another room, and if you don't have an attorney, then you'd be there by yourself. School people would be in their room. By and large, they're not supposed to have their attorneys there, but don't be shocked if they're in the adjacent room. All right, or on the telephone. So that's if you don't have an attorney. The other thing is that so caucus style would be that the mediator would come in and go back and forth between the rooms to try to broker an agreement. Okay. The mediator is impartial, and also the mediator will have you sign a form specifying that you agree that the process is going to be confidential. Okay. Now the reason that is that because you don't lose anything. All right, you're not losing any rights in mediation, which means that if your mediation doesn't work, then you still have the right to go to due process. You still have a right to file a state complaint. And the reason that the process is going to be confidential is because they don't want either party to have what they offered in the mediation used against either side. And that's why I'm telling you, it's confidential for a reason. I agree with why it's confidential. You want the school system to feel comfortable making an offering to try to resolve it. And they can't do it if they feel like later you're going to use that against them. Same thing for the parent. If the parent is a little bit flexible in mediation to try to get it resolved, but then turns around if they're not able to, and then hits the school system with the full brunt and says, forget that. School can't come back and say, but Your Honor, at mediation they were willing to take this. Well, yeah, it's a negotiation, of course. I do that all the time. You always want to give an apple or a carrot, to try to get these things resolved. And so it is sort of a give and take. But if they're going to abuse that process and then make you go the distance, yeah, of course, hit them with everything you got at that point. It only makes sense. But that's the thing. Mediation, I don't see drawbacks. I just don't. In some of our cases, we will try mediation before we file a due process complaint, depending on the school system and depending on the board attorney. Those are the two factors that I will weigh. Now, why would I wait to file a due process? If it is a school system that I have worked with and a special education director that I feel is proactive, that that the school system just stubbed their toe. This director can't be everywhere, and that's a lot of it. Is that you got these systems. There's just too many kids to sit there and know everything that's going on, and when I come across districts that I have worked proactively with, mediation makes sense because it tends to be a cheaper process. With regards to attorney fees at the end of it, and also, our ability to find that middle ground as quickly as possible and have it be done with. And, at that point, if you were able to reach an agreement at mediation, that's it. You sign your name and you don't go any further. That's it. And so what the signing of the name, and this is very important, guys, what the signing of your name at mediation means is that you have resolved all complaints, all issues going back to the full statutory period. So if you live in a 1-year statutory state, then your mediation agreement takes care of all of that. If you live in a 2-year statute, that's it. Now understand that the day after your mediation starts a brand new day. A brand new standard, a brand new requirement for the school system to provide your child a free and appropriate public education. And that would start on day 2, day 3, day 4. You just cannot file any more additional complaints on anything back to this date. This becomes your day 1. All right? So just understand that, because I have a lot of parents that they go in there and they end up with, let's say they don't have an attorney representing them, and they end up with a crappy result, and then somehow they want to try to undo it. You can't undo it. Can't undo a mediation. Once you sign your name, that's it. And then there's nothing you can do to undo that. The only thing you can do is if the school system fails to comply with the terms of the agreement, then you have the power to compel in federal court or through the due process mechanism as well, unless you live in a state that has like a review panel. So you'll have to check your parental rights on which state you live in. Now, what are the drawbacks for you? Let's say if you don't comply, nothing. The school system just is absolved from having to follow the agreement. Now, would that track if you left the district? Yes and no. It depends on how far away you go. It depends on how much time is still left in the terms of your mediation agreement. If they've already complied with everything in your agreement, then if you move, sorry, you moved. So it really does depend on what the promise was and what the terms state as to what happens if you fail to comply. But let's say that they offered summer services and then you didn't show up half the time. Well, if the fault is yours, then you cannot come back later and go, well, you guys missed 7 sessions. No, you missed 7 sessions. They didn't miss 7 sessions. So I do have that on occasion, and parents need to understand that once you get into these kind of agreements, you have your role, they have theirs. And you never want to put yourself in a position to where they can frame you as the problem. Comply. The stuff is meant to be corrective action for your child. And, if you get into these things and you start reading these mediation agreements and there's little to no meat for your child, but yet there's a lot of language benefiting the school with regards to things that you're not going to do and things you're going to, then their attorney's probably back there writing this for them. And you need to be cautious. It should be very balanced or more weighted for the benefit of the child. That's the entire point of mediation. It's corrective action for your child. All right. If you do bring an attorney, then, the rights are there. The fee shifting rights are there. That becomes part of the negotiation for reimbursement or payment of the attorney fees, which can be included into your mediation agreement. Just trying to. But if you end up, and I'll say this is my final note. If you end up not reaching an agreement at your mediation, then you just have a no agreement. You sign a little form that says, we could not agree, and that's it. All right? The terms of the confidentiality would still exist. That would be what goes with you. At the same time, you have lost nothing. All right? You can still file a due process complaint. You can still file a state complaint. Those options still exist. So as I stated earlier, I look at mediation as a win-win. Just make sure that prior to your mediation opportunity that you communicate thoroughly and clearly with your mediator so that they understand what the issues are. Try to stay away from emotion. All right? You're trying to show issues. You're trying to show to the mediator with the clear mind what the issues are. You don't have to be a legal scholar to do that. My child's regressed, and this is how my child's regressed. This is why my child's regressed, and have the stuff there to show them. But it is bad form for a parent to show up and have it be an emotional fest of feelings because, the legal world just doesn't care about that. We care about damage. We care about quantifying that damage. And in a way, a failure to provide a free and appropriate public education is damage. It's educational damage to the point where how do we make it better? Well, through corrective action, through additional services, remedial services. That's how we correct it. Okay, there is no money damages in special education. So please understand that. You can get reimbursed for prior expenses if you can justify those. Mileage can be reimbursed. Tuition can be reimbursed. Tutoring can be reimbursed. Equipment that you bought during this time frame for things that the school should have purchased. For example, if you've been asking for a communication device for your child, and then you had to go out and absorb that expense, then yeah, you would be entitled to reimbursement for that because the school system was on notice. They knew your child required it, and that's what the free and appropriate public education means. All right? And I know schools don't like when I say stuff like that, but that's the case.